This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author, and producer of these videos. Today, I'd like to talk about the adjustment of a commercial property loss. The adjustment of a commercial property loss is performed almost in the same manner as any other property loss. The difference is one of tone rather than substance. Adjusters who usually deal with a business entity and its officers or employees rather than an individual find claims handling is often, but not necessarily always, easier. The experienced adjuster who deals with commercial claims usually has knowledge of the business and the people who operate the business. Some insurers even assign a single adjuster to a major commercial insured to handle all claims presented by that commercial insured. Familiarity and a good working relationship over a period of months or years benefits both the insured and the insurer. A fire, of course, can be devastating for a business if the business is not rapidly put back to work after the fire is extinguished. The adjuster must recognize this fact and act quickly to complete a fair and thorough investigation. To adjust the commercial property loss, the adjuster must be familiar with the coverages and be ready to read and understand the policy. An adjuster must always be absolutely certain which endorsements apply to the insured. The adjuster always reviews the loss notice and re-reviews the coverages to ascertain which coverages apply to the type of loss reported. He or she makes immediate contact with the insured so that he or she may inspect the loss. If there is a potential loss of earnings, it is important to collect as much business documentation as possible so the history of the business can help the adjuster and his or her consultants to determine the amount of loss. Loss of earnings forms vary greatly. It is therefore important that the terms and conditions are explained to the insured and why the adjuster should collect documents for analysis, possibly by a forensic accountant. The records sought should include at least 4 years of corporate tax returns, 4 years of profit and loss statements and balance sheets, bank account statements and canceled checks, 1 year of source documents on payroll expenses, costs that continue, costs that do not continue, leases, contracts, and any other relevant business documents, and if business information is kept on computers, the software used, and a backup copy on a disk is necessary for the adjuster or the retained forensic accountant to work up the amount of loss. The adjuster must always conduct a thorough investigation at the scene of the loss. He or she must establish the cause and origin of loss and obtain a general idea of the extent of the loss and what expert assistance will be required to complete the investigation and adjustment. If cause and origin of the loss are not obvious, it is imperative that the adjuster retain the services of a cause and origin expert or an engineer to determine the cause and origin. For example, if it's a fire loss, the adjuster must decide if a fire cause investigator is needed. If it is a theft or business interruption loss, the adjuster must determine if the assistance of a private investigator and/or a forensic accountant is needed. If so, the adjuster should advise management of the insurance company that the loss requires the assistance of a company general adjuster who is more experienced and knowledgeable than the average adjuster. If a general adjuster is not available, the adjuster must determine whether the loss is too complex for his or her skill level or involves legal issues. The adjuster will then need to obtain authority to retain an insurance coverage lawyer experienced in major losses, commercial insurance coverage issues, and/or potentially fraudulent claims. The attorney will provide advice and counsel to the adjuster, who will assist as a lawyer the adjuster to make it possible to complete the adjustment of the complex commercial claim. If at any time in the investigation it appears that the loss is suspicious, that there is a possibility that fraud is being attempted, that the coinsurance clause may come into effect, or that there may be a penalty under the reporting form, or that a condition or warranty in the policy may have been violated by the insured, the adjuster must immediately ask the insured to sign a non-waiver agreement or issue a thorough reservation of rights letter to the insured. The non-waiver agreement is a mutual agreement between the insured and the insurer that nothing done in the investigation of the claim will act to change the positions of the party or waive any of the rights of either party under the contract. If the insured is unwilling to sign a non-waiver agreement because the insured does not understand it and wishes to seek the advice of counsel, the insured should be requested to seek that advice. However, since waiver could cause a problem, the adjuster should not delay the investigation for more than the time necessary to issue and deliver a thorough and detailed reservation of rights letter to the insured, since it bears the same weight and ability as a non-waiver agreement and is only different in that it is unilateral rather than mutual. The investigation continues pursuant to the reservation of rights or the non-waiver agreement. However, the non-waiver is preferred because it is a mutual agreement between the insured and the insurer, while the reservation of rights is a unilateral statement of the insurer. In Scottsdale Insurance Company versus MV Transportation, a 2005 decision of the California Supreme Court, the issue on appeal was whether an insurer that had properly reserved its rights could obtain reimbursement of its expenses of defending its insured against a third-party lawsuit, where it was determined as a matter of law that the policy never afforded any potential for coverage and there was no duty to defend. The court held yes in reaching its decision, and the court discussed at length its prior holding in Buss versus Superior Court, a 1997 decision. A Colorado district court found that the insurer properly asserted an exclusion from coverage. Moreover, defendants' reservation of rights sufficiently informed plaintiffs of the potential grounds for denial of their claim, as the letter included policy language describing several exclusions, including wear and tear, deterioration, weather, and faulty construction, design, or maintenance, the same policy language on which the insurer relied. This is a 2015 decision of the district court in Colorado called Gallegos versus Safeco Insurance Company. Though insurers sometimes send a reservation of rights letter, even when problems have not surfaced as a result of the initial investigation in first-party cases, this function is merely to protect the insurer against claims of waiver and bad faith. Some cases indicate that a reservation of rights letter somehow causes an insured to anticipate litigation. The Southern District of Florida, for instance, did not find that case persuasive in Gables versus Empire Indemnity in 2019. Now, commercial property policies sometimes require the assistance of a public insurance adjuster, who is an insurance claims adjuster who works only for the insured on first-party property claims. In California, a specific statute called the Public Adjuster Act is codified at California Insurance Code Section 15,000 et sec. The California Insurance Code defines a public adjuster as a person who, for compensation, acts on behalf of or aids in any manner an insured in negotiating for or effecting the settlement of a claim or claims for loss or damage under any policy of insurance covering real or personal property. Building Permit Consultants, Inc. appealed from a judgment entered after the defendants' several demurs to the First Amendment complaint were all sustained without leave to amend in Building Permit versus Mazur, a 2004 decision of the California Court of Appeal. The multiple claims alleged arose from and were based upon a voidable contract to provide public insurance adjuster services that were regulated and licensed by the Department of Insurance. Since Building Permit Consultants did not, and in fact could not, allege that it possessed the required license, and that failure has been raised and asserted as a defense to the enforcement of its contract, the trial court concluded that the contract was void, and all of the claims alleged by Building Permit Consultants necessarily failed. A public insurance adjuster is not practicing law and may practice the profession without being sanctioned by the bar of almost any state. The professional insurance adjuster will have no problem dealing with the public insurance adjuster if they are both professional and work together to set a scope of loss and to agree on providing sufficient evidence to prove the amount of loss. Since lay people, especially working in corporate entities, have little or no knowledge of how to present a loss, it is to the benefit of both the insured and the insurer that those commercial property owners engage the assistance of a public insurance adjuster. And as long as the public insurance adjuster is professional and is not engaged in any type of fraudulent conduct, the claim will usually be resolved promptly. Of course, the adjuster's fee, which can range anywhere from 3% to 40% of the recovered amount, it is best for the commercial property owner to negotiate a settlement amount and a fee agreement with the public adjuster. Any commercial property loss that is sufficiently large should be negotiated down to the smallest percentage available that the public adjuster is willing to agree to. This video was adapted from my book, The Compact Book on Adjusting Property Claims, 2nd edition, which is available as both a paperback and as a Kindle book from Amazon.com with details available at my website, zalma.com, by clicking on the link to the Insurance Claims Library, where you will learn about this book and the many other books I have written to help the insurance claims profession. If you found this video to be useful and interesting, please forward it to your colleagues, and it's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and blog postings. Thank you again for your attention.